Hi everyone, I am attorney Maudia Washington from Washington Law Offices. Today I wanted to do a very quick video concerning termination of tenancy. So basically there are three different notice of termination of tenancy that a landlord can provide to his or her tenant to end the lease or the tenancy agreement. So you in Illinois, you have those three different notices. First one, which is the most common one, is the 5-day notice. And what the 5-day notice is for non-payment of rent. So if your tenant's behind a month's rent, you're gonna serve the 5-day notice. It's very important when it comes to the 5-day notice and all the notice that I will go over, that the proper terminology and the proper language is within a 5-day notice, the 10-day notice, which is another notice I'm going to go over, as well as a 30-day notice. There is particular language and have an attorney to review your 5-day notices, because I have seen from every client who has come to me, every landlord who has come to me, except for one who owns a lot of property, the 5-day notice is incorrect or they did not serve it correctly. And the importance of the notice is to give the tenant notification that you're going to pursue legal action if he or she does not either move or pay rent or whatever the type of notice it is. A second importance of the notice, if you did not serve it correctly or is an improper notice, your case can be dismissed. So you can file a lawsuit, an eviction lawsuit, get to court, have the tenant served, and find out at trial or before trial you have an improper notice, or your notice has not been served properly and your entire case has been dismissed. You do not want that to happen. So let's get back to the 5-day notice. So the 5-day notice is for non-payment of rent. In the 5-day notice, certain things you cannot put in there. Late fees. Many landlords think you put late fees and they put damages, and it goes on and on and on. So I would strongly encourage you and recommend you to have an attorney to review your 5-day, 10-day, 30-day, 90-day, 6-day notice, whatever notice it is, to make sure it's proper. Next, you want to make sure that the notice is properly served, and this applies to all the other notices that I'm going to go over. So there's different ways to serve. You can serve by personal service, which means in-hand service, going to the tenant and giving them the notice. You can do substitute service, which means if the tenant is not home, when you try to serve them personally. If there's someone over the age of 13 years old who resides at the premises, you can serve that particular individual. And you can also serve via certified return receipt mail, which I do not recommend. I never serve this way. I do not recommend this. It's too difficult to prove, and there's so many different elements that goes into it. And also you have posting. And I have found out through my experience, a lot of landlords try to post a 5-day notice. No, that's a big no for many reasons. Posting is only for certain reasons. So my high recommendation is to serve personal service. And even sometimes when you serve personal service, the tenant says they never received it, in which you can prove it up in court that you did properly serve them. Okay, so those are the type of service. Next, let's talk about the 10-day notice. So the 10-day notice is for a breach of the lease agreement. So there's a written lease agreement and the tenant breached a particular rule or provision in the 10-day notice. Most of the time, the tenant cannot cure the breach, and you can file your lawsuit after the 10 days has matured. Again, in a 10-day notice, similar to the 5-day notice, there's certain provisions that you want to have in that 10-day notice for it to be valid. So you cannot just go onto your computer and type up a 10-day notice. If you have the right language that's supposed to go into 10-day notice, you can do that. But again, from all clients who have came to me and they are new landlords or things of the nature, or tell me they got it off the internet, I have to destroy their notice because it's incorrect, or they do not have certain provisions in there that is supposed to be in the notice. Next, you have your 30-day notice. So your 30-day notice means that you're completely ending the lease agreement. If there's a written lease agreement, you've given a 30-day notice to end the tenancy. There's something special about 30-day notice. There's something special about all of the notices. But about the 30-day notice, it's the most confusing notice, because even though it's 30 days, it is not 30 days. It can be 45-day notice. It can be a 55-day notice, etc. So when it comes to the 30-day notice and the 5-day notice, I would strongly recommend you to have an attorney to review or to draft your notices for you. If you can serve your notices yourself. Most of the time when landlords come to me, I just have someone who does service for me to serve the notices. Just keep it clean that way. So there won't be any confusion, or the tenant says it never got served. I have affidavits and witness and etc. etc. It can get a little bit messy when it comes to landlord-tenant disputes. So again, in Illinois, you have at least 3 notices. It is more, but that's a whole nother sector to go into. You have your 5-day notice with your non-payment of rent. 10-day notice is for your breach of a lease agreement, and your 30-day notice is to end the lease agreement, or to terminate the tenancy even if there's no lease agreement. If you have further questions, please contact Washington Law Offices. Our contact number is 888-586-4441, extension 1.